Good morning and welcome to today's webinar, Learn what Elder Law Attorneys are advising clients in 2022, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So welcome to those that are new to our educational webinar series and also to those that are frequent attendees. If and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time for Steve. You received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen to download at this time. For our professionals on today's webinar, welcome as well. You may receive 1.5 continuing education hours for attending. And per my attendance records requirements, please email me your ID number if I don't have it. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I will be doing on Monday. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this very simple survey to offer us your feedback about the presentation. Also, consider a consultation with Steve or a document review after today's presentation, and use today's presentation as a jumping off point to get your planning started. Consultations are a great way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. And we always look forward to being a resource to you and meeting you here at Elville and Associates. So before we get started, I'd like to offer Steve and the firm a proper introduction before we get started. And then we'll go ahead and start off with the presentation. So Elville and Associates, you should see my screen here. We were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have several different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education here a lot at Elville and Associates, and that's something that separates us from others. We do that through our planning processes with our clients. We do that through over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We are one of only 2 firms in Maryland to have an accredited CCP by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville and Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard him present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 7th time in 2022, and we'll have an announcement about 2023 very soon. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charitable organization he founded in 2014, and I am very privileged to be the executive director of. So if you'd like to learn how we are making a musical difference in the lives of children each day, please feel free to reach out to me at another time when we have more time, and I'll be happy to share our story with you. So with all that said, we're going to go ahead and jump into the presentation, and I'm going to pull it up here, which I should have right here. There we are. And here we are, Steve.
Thank you. Thank you so much, Jeff, for that introduction. And good morning, everyone. I see we have many people on this webinar this morning, and I'm so humbled and privileged to be with you this morning on this Friday morning here before Christmas and during the holiday season in general. So welcome, everyone, and happy Friday morning. Thank you for spending your valuable time with us this morning as we walk through what is happening in the world of elder law. What are elder law attorneys talking to clients about in 2022 and here almost 2023. And I say that it's such a privilege for me because it really is. Elder law is an ambiguous area of the law. It is a multifaceted area of the law, and we're going to talk about what it is and what it is not. And also, I know that many of you that are on this webinar this morning, you have a keen interest, whatever your interest may be, in a particular aspect of elder law. Perhaps that you yourself are facing certain elder care type issues, or you have a spouse or another loved one who is in a crisis or a pre-crisis situation. We want to be very sensitive to that this morning and hopefully bring information to you today that's very substantive that you can walk away with and really use this presentation to really honestly say that maybe more than 90% of people out there at what people know and don't know about elder law. You will be far ahead of what most people know because it is so ambiguous and the laws are hard to understand and all the state laws are different. But before we get into the presentation, again, thank you. And I thank Elville and Associates and all of our staff and attorneys for helping me to do what I do and what we do. And along those lines, I want to thank my longtime colleague and friend, Jeff, who is our moderator this morning. He is an absolute expert at moderating these webinars. He will take your questions. He will, if you have technical difficulties or anything, please let Jeff know. And we're going to stop occasionally through the next hour and 15 minutes or so to allow you to ask questions if Jeff sees that you have a question. So I want you to consider this kind of a mini master class on what is happening in elder law. And don't be afraid to ask Jeff questions. So Jeff, thank you for what you do. And again, happy holidays to everyone. Let's get into the presentation. So Jeff, let's go to the next slide. So we're going to start out by talking about what are the trends in Maryland. Well, as I've said many times on this particular webinar, Maryland remains one of the more liberal states in general about Medicaid and Medicaid planning. So right away, I've just jumped into something here that I want to explain. So when we're talking about elder care or elder law, that aspect of the law that deals with disability, long-term care planning, asset preservation, housing, social security, special needs, and more. This all revolves, as you might understand, around the world of Medicaid. And Medicaid is a federal program, and on the local level in Maryland, we call this medical assistance. In California, as many of you may know or have heard of, this is called Medi-Cal. So in Maryland, back on the East Coast, we call this medical assistance. So in general, I find that Maryland is fairly liberal in the sense that we can help clients with regard to, long-term care issues in many different ways. But in some ways, Maryland is not as liberal as it should be. And we're going to talk about some of those problems here in just a second. So Maryland has adopted an expanded Medicaid strategy for Maryland, and there's a lot to know there about the Affordable Care Act and what states have expanded Medicaid and what doesn't, who doesn't. And we're not going to be able to get into all that this morning, but just know that Medicaid at the outset here is a very broad umbrella of benefits, and we address issues in elder law, address issues in Social Security and special needs planning around this modicum or umbrella of Medicaid. So with that as the starting point, again, Maryland is pretty liberal. If we have someone in a nursing home, someone moves here from another state, if someone needs community-based medical assistance, and I want you to, if you have a piece of paper in front of you, I want to set the stage. Let's talk about the types of Medicaid, and we'll just get that right out on the table. I'm going to try to make this simple, although it's not simple, Just to give you an example, the Maryland Medicaid manual is probably a foot thick, and now it's on the internet, so we can easily look it up. But I want you to think in terms of this. On your piece of paper, I want you to write on the left side, I want you to write community-based medical assistance, community-based medical assistance. And then in the middle, I want you to write waiver programs, the waiver programs. And then on the right-hand side, I want you to write long-term care medical assistance, meaning skilled nursing, long-term care. If we think in terms of those three different types of Medicaid, now we're laying the foundation for understanding what Medicaid is. So let me just say this, and this will help you throughout this webinar. If I am a person living in the community and I have limited assets and income, to make a very long story short, I can qualify for community-based medical assistance. This is where I can get housing under the Medicaid system. I can get health care. I could get other means-tested programs through that system, and that's unlimited. So on your piece of paper, I want you to write unlimited. Then I want you to jump to the right-hand side, and that's that part that says long-term care medical assistance. If I qualify for this, if I spend down my assets, if I have limited means and I've met the requirements, I can get long-term care, skilled nursing in a nursing home, so to speak. I can get that unlimited, and that is a state and federal program. So if you think about it simply so far, we have unlimited community-based medical assistance, and we have unlimited long-term care medical assistance. But in the middle, we have those waiver programs, and this is what's very confusing. We're going to talk about that here in just a second. The waiver programs are where the federal government says to the states, you should offer these programs, but you can limit them. See, these unlimited programs are there, but the waiver program is limited. So the waiver programs, I should say, not program, but programs, include the community options waiver. This used to be called the older adults waiver. This is the waiver that says, well, I don't have to live in a nursing home to get medical assistance. I can live at home, or I could live in assisted living. And then there are many other waivers. There's the autism waiver and other DDA waivers. There is a adult daycare waiver. There is a traumatic brain injury waiver. So these waivers are wonderful if you can qualify for them, but they are limited. So let's go to the first one that I mentioned, which is the community options waiver. So as we talk about trends in Maryland, we want to know that Maryland is generally liberal about Medicaid qualification as compared to some other states, but Maryland is not very liberal when it comes to waiver slots for the older adults or the community options waiver. Now, many of you may have heard, well, how do you get this waiver? So I can live at home and I can have assisted living paid for by the waiver program, or I can have in-home care paid for by the waiver program. Well, the problem there is that Maryland is one of the worst in the country. And this is really difficult because we can't help clients the way we would really like sometimes in elder law. And we have to actually refer them to other states. Hey, why don't you live in New York or Delaware or Florida, where maybe the programs, well, not maybe, but the programs are more liberal. So that's a sad state of affairs that needs to change. However, there is some improvement in this area. So you may have heard that at any given time, there's somewhere between 20,000 and 25,000 people on the waiting list for this waiver or these waiver slots. So this is one of the problems. So Maryland is generally very liberal, and we can do a lot to get clients from point A to point B to preserve assets and to have nursing home qualification. But when it comes to having care at home, this continues to be a challenge, although some of our great elder law attorneys have worked tirelessly on this issue. And there is starting to be some traction on this with some new laws from last year, and it will continue to hopefully be developed. But right now, we continue to be really kind of on the bottom of the list. This is something that everyone in Maryland should be concerned about, that we would have more flexibility than just in long-term care skilled nursing. So We talked about the waiver programs in general. Let me go back to what's happening in Maryland. There are some legislative initiatives to change the Maryland statutory power of attorney. This is the simple statutory form that Maryland has that is very similar to the one in DC, Delaware, and New York and West Virginia. There is some talk about making it more expansive to include more elder care type powers. And we actually have a webinar on Monday that I'm not putting on this webinar, but we as elder law attorneys are going to attend a webinar where one of our colleagues is discussing the upcoming legislation to start expanding the statutory power of attorney, which we will talk about a little bit today. And this baseline document may be expanded in the upcoming legislative session to include more elder care powers. Going down here to number 3 on the list is the augmented estate. So I have this kind of couched as a problem, but it's really not a problem. And I'm going to change the slide actually, because this is a wonderful thing. The augmented estate is really something that I will call the new spousal elective share law. The new spousal elective share law. Now, the new spousal elective share law affects a lot of people who are married. If you're single, this does not affect you. And married persons can leave assets to each other, of course, however they like. And the augmented estate law simply says that everything in an estate, whether it's a revocable trust, an IRA, or 401k, the estate, so to speak, includes more than just a probate estate. And this expansive definition of an estate really, under this law, protects a surviving spouse. A surviving spouse is entitled to a certain amount. And that amount is roughly 1/3 at a minimum. So this protects surviving spouses. Now that may say to you, well, what does this have to do with elder law and elder care? And it really doesn't have much to do with elder care on the front end of that law. But on the back end of that law, if you would allow me to characterize it like that, there was a compromise between the estates and trusts folks in the Maryland State Bar and the elder law attorneys and the legislature to carve out an exception. And this carve out is really wonderful. And what this means is the settlement, so to speak, or the carve out was back in October of 2020, that if an elder care plan was structured properly, and we're going to talk about what that is, if this was structured properly, if there's a married couple and one of the spouses is ill and they are suffering from a progressive illness or a long-term impairment, there can be certain planning done. And through this planning, as long as certain criteria is met, the state of Maryland does not have a right of recovery. The state of Maryland can be excluded from a right of recovery and allow certain types of asset protection planning to be done. So that's a mouthful, but the augmented estate, or what is called the new spousal elective share law, has to do with estate planning mainly, but on the back end of that law, it has wonderful aspects for elder care and asset protection. And we'll talk more about that hopefully. The cost of care, unfortunately, continues to rise. Elder abuse, it continues to be addressed on the legislative level, on the local law enforcement level. So these things have not changed since last year. Obviously, we're still dealing with much of that and trying to combat it as much as possible. If you know someone who is being exploited, please let someone know. I have had clients that were perhaps referred to me through a court or where I worked pro bono in a certain case, and I've seen older adults lose more than $1 million of assets. I know you've heard of these kinds of cases. The scams are real. The problems are real. Please take it seriously and protect your older adult loved ones. Supported decision-making, and then we're going to go on to the next slide. Supported decision-making was in the works. It was in the legislative process, or the development of this law was forever in the last 8 or 10 years underway. Maryland has finally passed supported decision-making, and as of October 1st, 2022, supported decision-making is the law in Maryland. So what you need to know about supported decision-making is a lot, and we have a whole webinar about supported decision-making. If you would like to request that webinar from Jeff. He'll be glad to send that link to you. But I'll try to describe supported decision making to you in a nutshell. And I'm going to couch this discussion very briefly in this way. I want you to imagine, and maybe take out your piece of paper again, I want you to imagine that prior to supported decision making, we had an old paradigm. And that paradigm was the paradigm of guardianship. That paradigm was the paradigm of protection, protectionism, protecting someone with disabilities from being able to be harmed and to keep them from fraud and abuse and all of those very important things. But the paradigm of guardianship had its problems and still, in some ways, still has its problems, but it's a necessary evil. Let's just face it. On the opposite end of guardianship, we have the right of self-determination and no loss of rights, because in guardianship, we have a loss of rights, unless those rights are particularly mentioned in the court order. But let's go to the opposite direction. We have the right of self-determination, where someone can sign a power of attorney or advanced medical directive, and not just for the sake of signing it, but they're actually doing what? They are appointing agents. And when they appoint their healthcare agents and they appoint their financial agents, that is a substitute for guardianship. So the person who has the right of self-determination and they sign those powers of attorney and advanced directives and name agents, they are basically saying to the world, I want no guardianship. So we have this end of the spectrum, and then we have the paradigm of guardianship. Well, for years and years, there was nothing in the middle. It was these two extremes, and attorneys who are guardianship type attorneys, they would have to create all kinds of agreements and all kinds of creative measures to try to figure this out, because there was nothing in between. So now we have supported decision making. Supported decision making basically is this, and I'm going to let you take a breath here from hearing me talk so much in the last 2 minutes or 3 minutes about supported decision making. Get ready to write this down. Supported decision making is about persons with disabilities having the right, persons with disabilities having a right, whether they're young or old, persons with disabilities having the right to make their own decisions, to whatever extent possible. Persons with disabilities having the right to make their own decisions to whatever extent possible, provided that they have the support to do so. Provided that they have the support to do so. So now this new paradigm is, well, we don't have just these two extremes. We have this new thing, supported decision making. The idea that a person with disabilities is not necessarily trapped inside of a guardianship paradigm. This person may be able to move away from that paradigm and be able to exercise the right of self-determination in some way. And I have to admit to you, and I think many parents who are trying to take this in, parents with children with disabilities or families with older adults with disabilities, they're trying to take this in. What do you mean, Steve? We can move from the paradigm of no risk, meaning protection, to the paradigm of risk. So this is, in a nutshell, the ability of someone to exercise more right of self-determination and perhaps have a guardianship terminated if they're currently under guardianship, or avoid guardianship where guardianship is being considered. And as we move more to this direction of risk, see, the risk increases, and the person with disabilities now has the right to fail. They have the right to appoint someone to help them make their own decisions. So this is a wonderful thing in concept. It comes down from the United Nations mandate on human rights. It's a great thing. However, my experience so far is that many people are mystified by this because they don't know what it means to them. They don't know what it means to the persons with disabilities in some ways. So this is something we will wrestle with. This is a new thing in Maryland. And the last thing I'll say, Jeff, as we get ready to go to the next slide, this has to do also with Maryland's law is so broad, and it goes from where it was to such a broad scope that it even allows a supported decision maker to be appointed in guardianship. Someone could have a guardianship and still have a supporting decision maker. So beware of it. I wrote an article about this in our last newsletter. If you would like to receive that, it's a very long article, and I actually included the legislation in the article, basically. But I invite you to sit with this, read it, let it sink in, and I think you'll be quite overwhelmed by it. Okay, Jeff, let's go to the next slide. So why are clients coming to elder law attorneys in 2022? Well, many of these things will be commonsensical, many of these things will be intuitive, but hopefully I'm going to give you the nuances of some of these things today. So of course, age-related impetus, I call it. We are all getting older, we have issues, but I will say, I'm sitting here in conference room number 1 at Elville and Associates. I'm looking out the window. I'm looking at the empty chairs around me, and I'm looking at the chair over here to my right. And that chair is always a fond memory because 6 months ago, I had a man in my conference room who was 105 years old. And he was sitting right here talking to me about his elder care and his planning. And I'll say we've had many, many other older people. So people are living a long time. And as we age, we are going to have elder care related issues. And what is the difference between estate planning and elder law? A lot of you may want to know what that is. And I mentioned this earlier. Estate planning tends to be minimizing taxes, making sure that we're disposing of our assets properly, and protecting beneficiaries and all the things relating to wills and trusts, and taxation. Now, elder care is about many of those same things, but it goes in this direction about planning for disability, planning for long-term care, planning for asset preservation, Social Security, special needs, all of those things, assisted living contracts, all of those things. All right, so we're all getting older. People come to elder care attorneys to talk about these issues that are transitioning from general routine estate planning into the elder care arena. Pre-crisis planning. Pre-crisis planning in the elder law world is basically this. I'm still healthy and well, or my spouse and I are still healthy and well, and we don't have a crisis. We don't have any kind of serious issues going on, and God willing, we will not have any of those issues. But we're coming in advance of such a crisis, and we want to know what our options are. So think about that. That is what we call a pre-crisis elder care consultation, where we see where things are. Where's the current estate plan or the lack of it? And where do we go with that from there? And what options are available? Because elder care planning, like all planning, is goal driven, G-O-A-L, goal driven. If you know what your goal is, you can get from point A to point B in elder care planning. Sometimes in pre-crisis planning, we don't know what the goal is. We're just exploring and we're just finding out what is the lay of the land. What is all this ambiguous information I am told? Will I lose my house? You know, what is going to happen to my assets if my spouse or I, if we're married, we have an issue? Change of circumstances. This is kind of related to what I just said. We're living our lives, we're doing what we're doing every day, and now there's a change of circumstance. We've lost a spouse, or our spouse is impaired or has a progressive illness. God forbid someone has a stroke. Our own health is now changed, and maybe our healthcare agents are not available, or our financial aspects are changing. Maybe we don't have a planning team. Maybe we don't have a financial advisor and we need one. We sense that age-related problems are starting to occur. Or there has been a crisis meaning all of a sudden our lives have been turned upside down, either because of our own health or the health of a loved one. And now we need to find out what is the real deal with the laws. I can't tell you how many times, and Jeff has seen this as well and many of the other attorneys here, I can't tell you how many times, and I don't want you to fall victim to this. People are told, especially at a time of crisis, they are told incorrect information. Information that is not only incorrect, but devastating in its effect because of its inaccuracy about misinformation about how to qualify for Medicaid, or how to protect loved ones, or how to make healthcare decisions, or how to protect assets. These things are tragic because they cause so much pain and suffering at a time of crisis. We want to avoid that, and we're going to talk about what an elder care consultation is and how we get that information out. So we could have a crisis situation or a pre-crisis situation. We could have issues with our parents. Many of us have aging parents. I have aging parents, and they have elder care related issues, and maybe yours do too. That is why clients come to elder law attorneys. Grandparents issues, same thing. Disabled children. We have disabled children. Those children are either clearly so disabled that they are, quote, special needs persons, and they need to be provided for as such. Or that loved one or that child is kind of in the middle. It's unclear where they stand with regard to their capacity or their ability to be independent and so forth. So it involves all of these issues. Or it could be other loved ones in crisis, and the family is just at a loss as to what to do. Okay, Jeff, let's go to the next slide. Now, as we continue to go through these categories and subcategories, okay, we know people need this information. We know that it's out there. And now the question is, how do you disseminate this information if you are on the legal side? And this is what I'm trying to convey to you. This is now what elder law attorneys are really telling people, and we know what people and families need to know. So healthcare decision making, this is a big thing, right? Some people consider this to be the most important thing in elder care planning, is the healthcare decision making. So we want to make sure we understand that healthcare decision making in Maryland is pretty clear. You can go to the Attorney General's website, attorneygeneral.gov, and you can read about this. Maryland is one of the only states that requires a MOLST form, medical order for life-sustaining treatment, under certain circumstances. So you need to know what a MOLST form is. You need to know how it works. Your loved ones need to know how it works. Financial decision making. Now, from an attorney's point of view, this is the most important thing in elder care, because if you, as we will talk about later, if you have your financial decision making house in order, if you have powers of attorney that are properly structured, and in most circumstances, very flexible, very broad, that is the single most important thing that is something that you should learn about and implement, because without that, you cannot properly plan for elder care related issues. In-home care management. Okay, many of you are having to have in-home caregivers come in, or you're having to facilitate that for someone. Remember that you don't have to do it all yourself. You can have that managed by a life care manager. So let's go ahead and talk about that. The eyes and ears of an elder law attorney is what we would call today an aging life care manager. So there are aging life care managers out there in all kinds of shapes and forms today, whereas when I was a young lawyer, there were hardly any of these people available. Ones that I particularly enjoy using right now are Jill Rossner, who is a nurse, and also Allison Stanton in the Columbia area, who is a nurse. But there are many aging life care managers. If you don't know what I'm talking about, we used to call these people geriatric care managers. But when we're talking about in-home care and the management of in-home care, we want to think in terms usually of utilizing the services of an aging life care manager to make your life easier, but more importantly, to advise you about your loved one and their safety at home, or their safety in the assisted living, if it happens to be an assisted living. And that gets to the next bullet point. Elder law attorneys are talking to their clients about nursing home placement, assisted living placement. Many people have misconceptions about nursing home placement. Many people are under the belief that you must be wealthy to get a good nursing home placement. Now, let's be honest. Aging life care managers will tell us that there is no such thing as a good nursing home. But from an elder care point of view, we have to believe that nursing homes are following the rules, they're following the federal laws, and that there are good nursing homes, that there are nursing homes that are better than others. So we want to be sure when we're in the placement process that if you need assistance, that we are facilitating that assistance and that we're vetting those nursing homes and that we're dealing with them in the proper way, usually not only for placement, but also for protection of assets, which we're going to get to in just a second. Estate planning. So estate planning is a very important aspect. Hopefully, our loved one, or hopefully you yourself, have a base estate plan in place prior to a crisis. And that's what the pre-crisis life planning is all about. Again, base planning, regardless of your level of wealth, is at least a will as your structure. We're going to talk about that. And financial powers of attorney and an advanced medical directive. All of them are important. Arguably, the most important is the financial powers of attorney. Asset protection. The whole basis of much of elder law is the discussion of long-term care asset protection. Remember that the word asset protection, these words, I should say, asset protection, are very confusing. What does that mean? It's a hugely broad subject. So I tried to break this down into 3 categories. We won't go into 2 of the 3, but I want you to know that there is such a thing as what I would call lifetime asset protection. The asset protection that you have during your life that you may or may not even be aware of, such as asset protection in a qualified plan or IRA. Then we have what I would call asset protection at death. You can provide for your loved ones at your death. You can provide a trust for them and give them asset protection from creditors and bankruptcy and bad marriages. You can do that at death. But during life, there is this concept called long-term care asset protection. And that's what this slide is talking about right now. So long-term care asset protection is understanding the Medicaid laws, that big umbrella of Medicaid. Understand how it works on the local level and what is in the best interest of an individual or family, either pre-crisis or at a time of crisis, and how can assets be preserved. Now, of course, from an elder care point of view, we want you to have long-term care insurance when we're talking about asset protection. We're protecting assets by having that product, or a hybrid product, or a life insurance product that has a long-term care hybrid approach, or a rider, I should say. So we want you to have all of those things, but the truth is many people do not have those products. And so understanding asset protection is critical, even though we would hope that you would have both, that you have the understanding and you would also have long-term care insurance. But if you don't have long-term care insurance, it's critical to understand how assets can be protected. We want to understand how to limit liability. If you're having caregivers come into your home, or if you have informal arrangements with someone, you are just paying someone privately for coming into your home or caring for your loved one, you do have liability, and you want to be sure to address that. We want to talk about assisted living contracts and CCRC contracts, continuing care retirement community contracts, and nursing home contracts. Medicaid, medical assistance, how does that whole system work? What are the various parts and how do they relate? We find that nursing homes, surprisingly, or maybe not surprisingly, they are not very good at disseminating information that is in your best interest. They have an interest in private payment. Naturally, they are running a business. They are taking care of people and hopefully doing a good job at it. But your job and my job is to understand what are the laws and how do the laws relate to nursing homes and Medicaid, and what is possible to protect the assets of an individual or a married couple. Medicare many times comes up in the elder law context. Most elder law attorneys are not experts in Medicare, surprisingly, because Medicare is such a broad program on the federal level that the Centers for Medicare and Medicare advocacy out of New England is often a resource that we use for Medicare. But elder law attorneys do field Medicare related questions at times. And of course, we talked about special needs planning, whether it's planning for a loved one with disabilities by leaving our assets to that loved one, or that loved one has already received assets and now that's disqualifying them from Medicaid, and we have to take a backdoor approach to figure out what to do with that money and get it out of their name. Or, as I mentioned earlier, in the case of a married couple, where we have one of the couples, one of the members of the family unit, they have an impairment, now there are certain ways that special needs planning can be done between spouses. So that's a mouthful, but that's what elder law attorneys are talking to clients about. Jeff, let's go to the next slide. And before we get into what an elder care consultation is, Jeff, I'm just going to stop for a second, as I promised I would. And I've been going for over a half hour, and I want to take just a sip of water and see if we have any questions.
Thanks very much, Steve. We do have a couple. The first one is, older adult equals person with disabilities, right? Or do they need to have a medical proof for their disabilities?
Thank you for that question. If I extrapolate into what I think you're asking, I think you were asking, and I hope I'm not wrong, about the older adults waiver. And you're right in the sense that it doesn't necessarily have to be someone who's very, very elderly. It does apply to people with disabilities. And I'm sorry, Jeff, what was the second aspect of the question?
Or do they need to have a medical proof for their disabilities?
Yes, so this is going to be a program tested benefit. So this is a means tested benefit, whether it's one of the waiver programs, those are means tested, or whether it is in a skilled nursing home, obviously that's means tested as to whether a person has spent down. And that's the financial aspect, but the medical aspect is that the person would have to meet certain medical criteria to qualify for that program. Thank you for that question.
Okay. And last question for now is, do these laws apply to Pennsylvania residents?
Thank you for that question. That's great. So if you are a resident of Pennsylvania, Pennsylvania's Medicaid laws are going to apply. Now, federal law is an umbrella, but each state interprets their own Medicaid laws basically. So if you are a resident of Pennsylvania and you own real property in Pennsylvania, for example, or you were going to go into a nursing home or waiver program in that state, Pennsylvania, those laws would apply. Now, if you are a Pennsylvania resident, but you are going to move to Maryland, and you would be, God forbid, in a long-term care facility or in Maryland, then even though you were a Pennsylvania resident at that time, when you move to Maryland after a certain period of time, and it's pretty quick, you would be considered to be a Maryland resident for purposes of Medicaid.
Okay, that's everything for now.
Thank you, Jeff. So in the interest of time now, I'm going to move forward. So what is an elder law consultation? Everything that we've talked about so far is more or less encompassed in an elder law consultation. When I was a young lawyer, one of the first things I was taught, and I was very lucky to be in the right place at the right time to learn this concept, is a 2-hour or so elder care consultation. Now, this is something that most elder law attorneys have to charge for because obviously we are giving legal advice. But this is where the rubber meets the road. This is where the family or whoever is the person in interest here finds out what is really happening. It is fact driven. So let's look at this. It is fact finding. Many people swim in this sea of ambiguity and suffering mentally, and lots of just nerve-wracking concerns. And many of you may be experiencing that right now until the facts are shared with someone you can get counseling from, and we can identify problems and really identify what the goals are, right? Because let's say there's a couple, for example, and one of them is impaired. Well, that's a very, very sensitive situation about should assets be transferred from the ill spouse to the well spouse? What kind of strategy should be employed? Everything is goal driven. Incapacity related issues have to be addressed. The person who is impaired or not well, can that person still execute documents, and do they have the mental capacity to do this? Or are we stuck with no documents? The person cannot execute new documents, or the person, we're stuck with the documents they had before from 7 years ago. And what powers do they give us to be able to navigate this particular problem? An overview, I should say, of long-term care issues, medical assistance, again, Medicaid, community Medicaid, long-term care Medicaid, the waiver programs, asset protection techniques. There are various asset protection techniques for couples. There are various asset protection techniques for a single person. But as I mentioned earlier, and I'm going to, like Jeff and I sometimes say, I'm going to be intentionally redundant here. I'm going to drive home again that the financial power of attorney is the most important document, in my opinion, in elder law, in elder care. Make sure your financial powers of attorney are strong, flexible if that is appropriate for you, and that they speak to the flexibility that you desire to give. And for long-term care purposes, you need to give very broad flexibility, but every situation is different. And of course, I cannot provide legal advice about that on this webinar, but it is a very, very serious issue. If we don't have the proper financial powers of attorney in place at a time of crisis, then we do not have the flexibility that we need. Costs of care and long-term care financing, we just talked about that. Discussion of the advisory team. I briefly mentioned this a while ago. We want you to have a team. We don't want to be a silo, a person who is advising you eventually and say that we know it all, because attorneys do not have all the information. They have the legal aspect. They have the broad aspect of the legal, and that does kind of morph into the tax planning and also the financial planning. But we are not financial advisors and we are not CPAs. So a CPA and a financial advisor, and in some cases, an insurance advisor, and in some cases, a life care manager, in many cases, a life care manager. This is the advisory team. This is the team that we want to have in place, and we strongly recommend that that's part of the elder care consultation. And then this may not seem important, but this is a big thing. Recommendations and next steps. When I was a young lawyer, most of the advanced or older elder law attorneys at the time, I noticed, would provide wonderful information to clients, but would not necessarily commit to next steps and action items. And that may seem nonsensical to you, but I've actually witnessed this many times. Lawyers many times fall into the trap of educating clients and telling them all that they know, but the client needs next steps. They need to be proactive. They need to know what they can do and how to make it happen. And that is part of a good elder law consultation, in my view. All right, Jeff, let's go to the next slide. Now, why does this elder law consultation provide a shift or a transition for change? Well, it is the basis of this change. Someone is having an issue. Someone's having an aging related issue. Someone is seeing something develop. Someone is having family issues, heaven forbid, and the children aren't getting along, or someone doesn't have a fiduciary, okay? These are red flags. These are flashing red lights. This tells us that we need to change our planning. A couple where the spouses were healthy and now one of them is not. This is a basis for a shift change. So this elder law consultation addresses that. It resolves ambiguities and misconceptions. I talked about that, and I'll just give one more story. I once met a lady at a restaurant. This was the pre-COVID days. These were years ago, where many times I would travel to meet clients at locations. And I met this lady at a restaurant because she was in crisis. And I think it took me 20 minutes just to be able to get her to stop crying, because she was under such anxiety, such emotion from misconceptions that she had been told from a nursing home. We want to relieve this anxiety and hopelessness. We want to do that with facts, not fiction. We want to give people a sense of direction. This is what this elder law consultation does. A good elder law consultation gives someone the action steps and direction that they need. It gives them a sense of empowerment in many instances. Now I have the empowerment of knowing the information. I can make intelligent decisions because I know what my goals are. I know what I need to do. And if we still don't know what the goal is, we continue to work through that. It can create a foundation for family unity. So many families are very cohesive. And if you have one of those families, you are truly blessed. And that's a wonderful thing. You're going to be able to weather storms of elder care, whatever may happen. But where families are not cohesive, where there are weaknesses, the elder law consultation can help identify those things and how can we best deal with this problem that has developed within the family or has been developing for years, and how do we address that in the best interest of the person or couple who is suffering an impairment, is in a nursing home, or is having a long-term care issue. Okay, Jeff. Now, we talked about lifetime asset protection, long-term care asset protection, and asset protection at death. I mentioned that, and now let's go through that briefly. Jeff, let's go to the next slide. I had mentioned lifetime asset protection. Now, this is the slide that will give you that information. This is usually not, as I mentioned earlier, not what we're talking about in elder care. So why am I bringing this up? I want to segregate this stuff out so you have a way of thinking about it, okay? You can't think through these issues if you don't understand the different kind of categories or subcategories of information. If you're married, tenants by the entireties gives you general asset protection of a certain minimum type. If you have life insurance or annuities and you're married, or if you name your spouse or child, even if you're not married, you name your child as the beneficiary, those are protected from creditors. Qualified plans are protected from creditors. But inherited IRAs, those IRAs that we receive from someone at their deaths, if we're not a spouse, if we're a non-spouse, there's no asset protection for those. And in some states, there are domestic asset protection trusts such as Delaware, Nevada, Alaska, South Dakota. That is lifetime asset protection, not elder care protection. Jeff, let's go to the next slide. The elder care or elder law type of asset protection in the long-term care context, this is one of the most important slides in the presentation. We use Medicaid trusts. This allows you to divest. Remember, elder care is about divesting assets and trying to save assets many times from a nursing home spend down. This is a way for you to, or a loved one, to be able to divest assets without giving up all control, without giving up tax advantages. So this is arguably one of the most powerful tools in elder care planning. For a person who is a veteran or a veteran spouse, and you are eligible for a VA pension, and the VA has many pensions, we're talking about an aid and attendance benefit, the VA aid and attendance pension. The use of a veterans asset protection trust, which is similar but different than a Medicaid trust. This is an irrevocable trust that allows for planning specifically for veterans pension benefits. The use of trust established under wills. This is a more fancy way of saying what I was saying earlier. If a couple is married and they have one of the spouses with an impairment, and that impairment is progressive, that impairment is going to really affect the marriage, and there's going to be long-term care costs and a progressive decline. This is one of the most powerful techniques in elder law, which is to plan between the spouses to be able to utilize a trust that is established under the will of a person to die. And this is the person who is well. In this strange scenario, the person who is well dies first. Now, this is usually not the case, but do well caregivers, well spouses who are caregivers, do they sometimes die first? And the answer is yes. Not very often, but they do. And in this technique, the assets can be moved to that well spouse, in basically speaking, and if that well spouse were to die first, which is probably not going to happen, but if it does, this is an asset protection technique that is allowed under the federal and state law. The augmented estate, or what I should say more accurately, the spousal elective share. We talked about that. It mainly affects estate planning in a general sense, but it also is a carve out for elder care planning. So when a spouse dies, if they are the well spouse and they leave a trust for their surviving spouse, and that trust is protected from the claims of Medicaid, it is protected now under Maryland law because of the carve out that was agreed upon in the new spousal elective share law. So proper planning in that situation would mean that if the well spouse died, many assets or even all assets could be preserved for the ill spouse, for the spouse that survives, and then at his or her death, the assets are translated down to the family members, and there has been a lot of asset protection in that scenario. Crisis planning. If we have crisis planning, there is something called the 5-year period, and we would not in the crisis plan be able to get past this 5-year, 60-month period, as we would hopefully in a pre-crisis plan. So in a crisis plan, if you're married and we have those proper powers of attorney in place, ideally, then you're going to be in a great situation, even though it's a horrible situation, but you're going to be in a great situation legally to be able to preserve as many assets as possible, doing something we call a Medicaid spousal spend down. That's a whole different subject for another day, but that is what you're planning for. You're getting that base planning in place so that you have the flexibility to deal with that situation. If you are a person who did know pre-crisis planning, or you're a surviving spouse, you're now a single person, or whether you were ever married and you're a single person, there is something in elder law called the rule of halves, or the half-loaf strategy. So under the current law, approximately 50% of the assets could be preserved even if you've done no pre-crisis planning, except for getting those base documents in place so that you have that flexibility. Life estate deeds can be used. A life estate deed can be a deed where you transfer it from yourself to yourself for life, and you have the lifetime right to live there. Now, if you keep the right to sell the property at any time, I have the right to sell this property and I'm moving to Florida. Well, there's no Medicaid asset protection there. But if you give up the right to sell the property, now you have started the 5-year period. That is what we call a divestment of assets to others, which are called in this context the remaindermen. And if you do that, now you've started the 5-year period. This is a simple way of doing asset protection for a piece of real estate, but there is no real flexibility in the planning itself. So sometimes this is not the right way to go, but it is something that you can do in elder law if you give up the power to sell the property, which is a very serious counseling issue. Okay, Jeff, let's move on very briefly to the next slide. And this next slide is asset protection at death. This is an ancillary tool in elder law. And I'm not going to spend a lot of time on this slide, just in the interest of time. I want to make sure we have time for questions at the end. But remember that there is this wonderful ability to plan for death with trust, whether it's planning for spouses, planning for children or grandchildren, nieces and nephews. You can protect them from the claims of creditors through spendthrift protected trusts. You can structure trust protectors. Trustee selection is one of the most important things in the world in estate planning today. We do have a trustee selection workshop. If you would like to get that link, Jeff would be happy to send it to you. And this is, again, one of our most popular webinars. Don't miss that trustee selection workshop if you're concerned about that. And of course, special needs planning is planning for death. At death, we have the special needs trust that is there to protect our loved ones with disabilities. Okay, Jeff, I'm going to stop again and see if there's any questions, and then I'm going to power through to the end. Jeff, I can't hear you. I think you might be muted.
I apologize for that. We do have a couple questions, and the first one is, can this information be put in an estate plan or in a list of instructions?
Thank you for that great question. Yes, partially yes. You can incorporate this kind of planning in your powers of attorney, and that's really a difficult thing to try to describe by way of this visual media here. In the power of attorney, most people think powers of attorney are strictly, I don't know how to say this, legalistic documents that's just strictly are one-dimensional. It's the best way to put it. But the truth is that powers of attorney, in my experience, are basically an explanation to your agent of what your philosophy is. In other words, it's not just laying out a bunch of legal concepts. It's really saying to your agent, here are the powers that you can have. These are the powers that I'm giving you. And I want you to be able to use those powers in usually a very broad way. So even though you can't incorporate all these things into your planning right now, you can incorporate them into a financial power of attorney that philosophically speaks to how broad powers do you want to give your agent. Now, back to your will or trust, you can't bifurcate is the best way to say it. You can't have a routine will that kind of morphs into a Medicaid trust. That is called a trigger trust. And back in 1993, the federal law protects and says, well, we don't want people to be able to do that. We want to make people basically have to plan proactively for these things. So it would be nice to be able to say, well, I'm planning for a routine planning, but if I have a long-term care issue, it's going to switch to this plan. Well, the government kind of kiboshed that a little bit, and we can't really do that. But through maintenance and updating of your plan, through diligence of your plan throughout your lifetime, you can address these issues and be on top of them should a crisis occur. Thank you for that great question.
Okay, and the last question for now is, do you only work with Maryland residents for elder law planning?
Well, thank you. Yes, I am licensed in Maryland, and sometimes we do work with clients from Pennsylvania or Virginia or from DC. We have attorneys in our firm that are barred in DC. Mainly my practice is in Maryland. If you live in an out-of-state location, we can help you get connected with a certified elder law attorney or that we can collaborate with, so that we are helping you and getting you situated with the right information at the appropriate information for your state.
Okay, and we do have one other question I could probably field. Do you have a list of webinars that we might select from to watch? And that's a great question. We do have a YouTube channel that houses all of our webinars that we've offered the past couple of years on video. So I'll be happy to send out that YouTube channel link in the email follow-up I always send out after each webinar. And that is going to have all of the videos that we've had over the past couple of years and more that you should be able to choose from at your leisure. Okay, thanks, Steve.
Thank you. Thank you. All right, and thank you everybody for hanging in there now. I'm going to talk for about 15 or 20 more minutes and then we're going to be done. Let me just continue on. And again, I know this is slogging through a lot of information. Thank you for hanging in there with me. What are clients seeking inside these elder law consultations? Well, some of this you're going to intuitively know, and much of this you may be already thinking about. How do I pay for the cost of assisted living or long-term care? Will I lose my home? How will I survive if I'm a spouse? How will I survive in the community if I'm a well spouse? Okay, government laws are not perfect, but they provide for this, and they hopefully will get you to that point. Can we preserve any of our assets? Well, this is part of the elder law consultation. What do? I'm lost. I just don't know what to do. How do I deal with placement? Okay, maybe we do that ourselves here at Elville & Associates, for example, or maybe we do this with the assistance of a life care manager. Healthcare decision-making issues, as I mentioned, which are covered in a consultation. Will I need guardianship, or can we get by with a substitute for guardianship, or with the existing powers of attorney, which hopefully are available? Okay, Jeff. How will I pay? Okay, here we go. I'm sorry, Jeff, keep going. Can I get veterans benefits? And of course, as of around 2018, we are dealing with new rules from the VA. I can't believe it's been that long. So these are different but better sets of rules from the VA, and we are now happy to say that we are much more acclimated with the new VA programs, and the VA, I should say, is much more acclimated to dealing with attorneys. Asset titling questions. How should my assets be titled in such an elder care context? Asset titling is arguably the most important thing in estate planning and in elder care, because if assets are not titled properly, they will not flow properly with the plan. How do I deal with or care for my loved one? This is in-home care, the services of a life care manager, understanding the Medicaid laws, understanding that you must take care of yourself if you're a caregiver. We live in a continuing care retirement community. Can we still take advantage of the Medicaid laws, or can we get veterans benefits? All of these things are what clients are talking about and generally what they want to learn. All right, Jeff. Now, again, this is a time of transition. Many times it's a time of having to confront issues. What are those issues? Well, could be anything, but changes to the estate plan. These are hard questions. Will my impaired spouse no longer be my agent? Well, usually that's right. Your impaired spouse is not going to be able to make your decisions for you. We have to shift to other agents. Healthcare decision-making, placement, Transfers of assets. Again, if you're married, and I know many of you may not be married, but if you're married, do we transfer assets away from the disabled spouse, the spouse that is not well? If we are single, are we wanting to divest assets 60 months ahead of a crisis? Okay. One of the big ones here, and you could put a star by this one. What is the level of care of my loved one? Many people are not sure about this level of care issue. This is why a care manager or a geriatric care or life care manager can be hugely important, because if you're dealing with a loved one whose health is declining, you're dealing with the cost of care, you're dealing with the system, you're dealing with trying to figure out, how can I get benefits? What is the best place for my loved one to live? Can I care for this person? Can I continue to care for this person? A life care manager is hugely important to help you understand not only safety issues, but what is the level of care? Because if you understand levels of care, you'll know whether you have the option, as terrible as it may sound, to place your loved one in a nursing home, or whether you won't be able to do that because their level of care is not high enough, that they only qualify, so to speak, for assisted living levels of care. So these level of care issues are, to us on the legal side and to you on the medical side and the personal side, hugely important. Okay, Jeff. Now, I'm going to attempt to give you a summary of what you could expect if you ever have to seek the advice of an elder law attorney. And I'm just going to hopefully extrapolate this into your consciousness as something that hopefully you could understand. Over the years, I have counseled, I would say, thousands of people about elder care issues. And about 5 or 10 years ago, I realized that basically these things come down to about 3 or 4 categories. And of course, I could be overstating this, but I think generally speaking, this is true. So if it's okay, I'm going to ask you to generally accept these 4 things that I'm going to share with you as the results of what one might expect to walk away from an elder care consultation. And we'll start with the married couple. So I find that the first tier, or the first level, is really the wait and see approach. Now, the wait and see approach is someone is in a crisis, or a quasi-crisis, I should say. This is a pre-crisis. But there could be some signs that something is happening and there needs to be an elder care consultation. Well, this is what I would call getting the basic plan in place, making sure that our wills, or that our revocable trust, but most importantly, our powers of attorney and our advanced medical directives, making sure these things are in place, that they're appropriate, that they're appropriately flexible, and that we've built the maximum amount of flexibility based on our circumstances that we're comfortable with. This addresses the cost of care in advance, gives the lay of the land, full education. But the main thing here in this tier 1 is what? We have laid the groundwork for the basic estate planning documents, especially the powers of attorney and advanced directives. Now, number 2, married couple. They're there for a reason in this consultation. There is something happening. So if it's a spousal situation like this sample says, the issue now that we've laid the groundwork, the issue is, should we, in that situation, transfer assets out of the ill spouse's name, out of the disabled or soon to be disabled spouse's name? This is really the divestment of assets from that spouse over to the well spouse, okay? And there are certain types of crisis planning that can be done here, or actually pre-crisis planning. Now, this same couple might say, we're going to divest assets. We're going to, actually, both of us are okay, but we're going to get assets out of our name. Maybe we don't have an impaired spouse, but we're going to divest assets either outright, which we don't recommend for tax reasons and control reasons, or in certain types of trusts. So this is a situation where we are either waiting and seeing in tier number 2, but we are going to do some asset transfers between spouses, or and now we go to tier number 3, if we are in a pre-crisis and we've got some time to think about this, nothing has happened, we are not facing a healthcare crisis, Do we want to divest assets either outright or in trust? And then the fourth tier, and I'll summarize this again, the fourth tier is really between spouses, understanding that if we do nothing more than tier one, if we do nothing more than get those basic planning documents in place and build flexibility, that if one of us has a crisis and we are in a nursing home, and for example, in Montgomery County, Maryland, the cost of care is $16,000 a month, let's say, something very, very high, and we're having difficulty dealing with that. Well, we know because we did this base planning, we know that we can spend down, we can preserve assets. We know that we're going to be able to, under those terrible circumstances, we're going to be able to preserve as many assets for the well spouse as possible. So to summarize this, and I apologize, I didn't explain all the four tiers as well as I would have liked to in that last 5 minutes. We have basically four tiers in my way of thinking in elder care and a married couple consultation. We either have a wait and see approach where we know that we're either in a pre-crisis situation or a quasi-crisis situation, and we're going to get the flexibility that we need in place with full educational counseling. Tier number two would be, well, do we want to, based on the circumstances, transfer assets out of the name of a disabled spouse or not? Number three, regardless of the situation, but usually in a pre-crisis situation, do we want to divest assets? This is the big divestment of assets, and that has to be very specifically a goal of yours. That is not a small thing. So you have to be very focused to do something like that. Arguably, the Medicaid Asset Protection Trust or the Veteran Asset Protection Trust is the most important or powerful tool that we have in elder law. Or lastly, level four, if you have those basic documents in place and you have a crisis, you're married and you need to spend down assets to protect yourself from the long-term costs of care, now you have the flexibility to do that, and federal law protects the well spouse as much as possible, and there are strategies to be able to do that. Jeff, let's go to the next slide, and I'll begin to wrap up as soon as we can. This is for an unmarried person, a single person. It could be a surviving spouse or someone who was never married. Again, we have these levels just to try to get you to have some context. That's all this is. One is the same. We get into a pattern of having this counseling. We have addressed all the costs of care and the avenues for that based on that circumstance, and we've built the maximum amount of flexibility that's possible. Wills, powers of attorney, advanced directives. Or two, we're in a pre-crisis situation. There is no spouse here. Now, why do we only have three choices here, basically? And in my examples? Well, because this is an unmarried person. Unmarried person really does. They don't have much flexibility, which is terrible to say, but they really don't have that under the law. So here we go from a wait and see approach to, well, hopefully this person is not in crisis and they can do some pre-crisis planning, outright or in trust. Three, this is the person who is either single or a surviving spouse. And you may have heard me mention earlier that in a situation where a person has really done no advanced planning, but they do have the basic flexibility planning in place, now we can preserve about 50% of the assets if that person has the flexibility in place to be able to do so. These last two slides are really just meant to try to give you a lay of the land, a perspective on how to think in terms of an elder law consultation and what you can walk away with under those circumstances. Jeff, let's go to the next slide. Incapacity planning, we've been talking about that throughout this webinar. Nothing is more important in elder care planning. Jeff, let's go to the next slide. Here we have the powers of attorney and advanced directives. They avoid guardianship when properly done, and we have our agents. But again, without this flexibility, we are stuck with court orders under guardianship, and we don't want to be in a position where our spouse or our loved ones have to go to a court and get guardianship of our person and property, because we won't have the same flexibility to preserve assets or whatever other goal that you have. All right, Jeff. The Maryland Power of Attorney, as I briefly mentioned earlier on, is part of the Maryland Power of Attorney Act. Now, the statutory form there are two types. One is a long form, one is a short form. Many estate planners in Maryland use the short form because they also will accompany that form with a customized document of their own, like a general power of attorney. But the reason why in elder care, the statutory form is not sufficient is outlined on these slides. And I'm not going to go through every one of these in the interest of time, but I want you to take away from these several slides that we don't recommend that you just have a Maryland statutory power of attorney for elder care related purposes. We want to layer that with at least a general power of attorney that is broad enough to allow your agent to have the flexibility they may need to be able to do the things for you that may need to be done or for your spouse under crisis type circumstances. Okay, Jeff, let's go to the next slide. Healthcare decision making. For many of you, nothing could be more important. Again, I'm not saying healthcare decision making is not important. I'm saying that the financial decision making and the financial powers are important from an asset preservation point of view. From an advanced directive point of view, we want you to customize the advanced directive, and I would like you to use these bullet points to understand that this document can be customized, and it takes a little effort, it takes a lot of thinking, it's not easy to think about these issues, but again, there is no such thing as a certain type of form that you have to use. We strongly recommend that you customize your advanced directive. Okay, Jeff? The MOLST form, Maryland is one of the only states that requires MOLST. You need to be educated about it. It is a doctor's order that is signed by a doctor or nurse practitioner. What does it have to do with elder care? Well, it has to do with what happens when someone goes into a facility. Many of you now, after MOLST has been around since 2013, 2014, many of you know what this is. I'm just trying to make sure that not only you know what it is and understand its relationship to an advanced directive, but also that your fiduciaries, your trusted agents, that they know what it is. All right, Jeff? Now, as we get to where we want to be, which is about 10 minutes left until the time we are going to stop the webinar, I hope that you've been able to follow me and go through the ambiguities of elder law and understand the various aspects and how to think about it as I've attempted to convey that to you today. I want you now to think in terms of what is my path forward? We're here to educate. We have 4 conference rooms. We want to warmly invite you to just take the time to think, as I'll talk about in just a second, to understand that these things are not easy to think through. What questions you might have tax-related questions, estate planning-related questions, and some of those questions morph into elder care questions. You may have questions about parents, children with disabilities, your own health. We understand that there's a lot going on in the world today and in your lives. So we want you to complete an elder care or estate planning questionnaire. We want you to know there's nothing to fear. But this is difficult. It's difficult to share information with people you've never met in person. We want you to know that we're counselors at law. We want to be here to invite you, for example, to ask questions, to bring a list of questions with you, and to understand that there are various types of discussions we can have, and it's confidential. We just want to give you a path forward. We know that it's not easy. We want to talk about whether you have an advisory team. Do you have a CPA, a financial advisor? Do you have a life care manager? And do you need a referral to one? We want to look at your existing documents, so don't be afraid to bring those. Generally, we do not charge to review existing estate planning documents, so we want you to bring those binders and bring those documents in for us to take a look at. But ultimately, what we're trying to do at our firm is we're trying to give you the time to think. So we're living in a very fast-changing, challenging, post-COVID world. And again, here at Elville & Associates, we have advanced technology in each one of our conference rooms. We want to be here to counsel and give you the time to think. So Jeff, I want to thank everybody for joining. I'm going to turn it back to you. I wish you a happy holiday season. I hope you've been able to take away something substantive from this workshop that you can use, that you can think about what to think about elder care and elder law in 2022 and now going into 2023. Happy holidays to everybody. Jeff, I think you're still muted.
How many more times am I going to do that today? I'm so sorry. Thank you again for a great presentation, Steve. A lot of great information, a lot of positive feedback, information I think a lot of people needed to hear, and that's why we had so many attendees today. So now would be your time to get those final questions into Steve. If you have any that you haven't asked yet, and we do have one here that I want to pose to Steve right now. That question is, for an elder law consultation, do you advise to come alone or with the person who is named as your executor?
A wonderful question. Thank you. I think every circumstance is different. Every relationship like that is different. And I would say there's no harm in it as long as you understand that when you bring someone with you, you are waiving attorney-client privilege. So when you bring someone with you, that could be very much appropriate, right? You want to bring that person so you're educating them and they understand the lay of the land and how it relates to you. So chances are that's probably the right thing to do, but you want to make sure now that you're sharing confidential information, that it's okay with you that this person hear that from a legal point of view.
Okay, and doesn't look like we have any further questions for right now. I will be sending out a substantive email follow-up, as I always do with our webinars. Some video links that Steve alluded to. I will send a link to our YouTube channel that houses all of our webinar videos, information about MOLST, a link to Steve's supported decision-making article, and some other information that we talked about today. As far as our webinar series, we are rounding out the year here. We do have our wellness series on December 20th, which is going to be a celebration of gratitude. It's going to be our 14th installment of our popular wellness series. And then we're going to take a little break until January. We're going to start off the year right with our Maryland ABLE webinar that we offer every 6 months on January 11th. And then on January 25th, Steve will be back to talk about how to achieve perfection in your legacy, intentionalism and estate planning. That's always a popular presentation that we try to offer once or twice a year. So thank you for being part of our presentation today. Consider a consultation with Steve if you have any elder law or estate planning, special needs planning needs. We want to be a resource to you here. You can always email me, email Steve, email his assistant, Mary Kramer at mary@elvilleassociates.com. Fill out the survey and let us know how we did today. And we always look forward to hearing from you here at Elville & Associates. So thank you for being here. Have a wonderful holiday if we don't see you beforehand. And thanks for your relationship with Elville & Associates. Have a great day.